Atheists Talk. I'm your host, Joseph Homrich, and today we're discussing the newest member of the United States Supreme Court, Neil Gorsuch. According to Wikipedia, Neil Gorsuch was born August 29, 1967 in Denver, Colorado. He is the son of David and Ann Gorsuch. He attended Christ the King Catholic School, graduated from Georgetown Preparatory School, a Jesuit school in northern Bethesda, Maryland, in 1985. He then received a Bachelor of Arts degree in Political Science from Columbia University in 1988. He then attended Harvard Law School, where he graduated cum laude in 1991. In 2004, he received a Doctor of Philosophy degree in law from the University College of Oxford, where he completed research on assisted suicide and euthanasia. While at Oxford, Gorsuch met and married his wife, Louise, an Englishwoman and a champion equestrian on Oxford's riding team. He has served as the law clerk for his current colleague, Anthony Kennedy. Later, he was principal deputy to the Associate Attorney General, and while at the Justice Department, he was in charge of all litigation arising from the War on Terror. In 2006, he was appointed to the U.S. Court of Appeals for the 10th Circuit. And to discuss Justice Gorsuch is my guest today, George Kane. George Kane is a member of Minnesota Atheists, a longtime member. He writes the monthly news and notes column for the Minnesota Atheist newsletter. Welcome, George.
Thank you.
I wonder if you could talk today on matters that may concern the free thought community. First question, maybe obviously, is has Justice Gorsuch dealt with any cases concerning the separation of church and state since joining the court?
Yes, Joseph, there have been a couple. Most importantly, Trinity Lutheran Church v. Kommer, which I expect we'll talk about quite a bit tonight. And also there is a certiorari case in which he dissented, and that was Pavin v. Smith. And we'll probably get to that too.
All righty. Could you tell us what was Justice Gorsuch's role in the Trinity Lutheran Church versus Kommer case, and perhaps bring us a bit up to speed on that?
Yeah, I have to go way into background to start off the discussion of this case. This case, which involves a Lutheran church school, and the state of Missouri had a program where they would offer subsidy if schools would repave their playgrounds with a rubberized pavement that was made from recycled automobile tires. And the trial court, rather the circuit court, ruled against the school. Now, this case was granted certiorari by the court. That means that they will hear the case back a month before Antonin Scalia died, at a time when the conservatives could count on a 5-4 majority on the court. So after Scalia's death, for a long time, Justice Roberts, the Chief Justice of the court, did not put the hearings for this case onto their calendar. So it just sat and waited until finally they had a ninth justice, presumably because they expected that the court would be hung 4-4, in which case the judgment of the circuit court against the church would have held. So once Gorsuch was sworn in, then Roberts put the case on the court's docket. So what does this case involve? This goes into deep background too. Back in 1875, U.S. President Ulysses S. Grant proposed in a speech that there should be a constitutional amendment to stop taxpayer funds being used to subsidize sectarian schools, private sectarian schools. And this was a very popular idea at the time. So shortly after this speech, James Blaine authored a constitutional amendment to have this enacted for the nation. And there are a couple of routes to have constitutional amendments approved, but this one started off in Congress, and it passed in the House. It needed 2/3 majority in the Senate, and it just failed to get this 2/3 majority. So the constitutional amendment failed. But it was such a popular idea that it was picked up by many states, and they introduced amendments to their own state constitutions. And in fact, it was passed in 38 states by now, have these so-called Blaine Amendments, named after James Blaine, who introduced the amendment in the U.S. Constitution. It's sometimes argued that, well, this was anti-Catholic bigotry. Well, as I understand it, in some states, indeed, anti-Catholicism was part of the discussion. But that certainly wasn't the case everywhere. And the current standing virtue of the amendments is that it ensures that taxpayer money, public funds, will not be used for the benefit of any religious sect. So that is the underlying importance of this particular case. When the Trinity Lutheran Church School applied for this grant to rubberize their playground surface, their application was denied because granting it would be in violation of the Blaine Amendment to the Missouri Constitution. The Circuit Court upheld the action of Missouri, that they acted properly in denying the application. And then the issue went to the Supreme Court, where it was considered as an Establishment Clause case, but also as a freedom of religion case, mostly as a freedom of religion case. The issue being that is this group being prejudiced against by being a religion and holding religious tenets, and they're thereby disqualified for receiving a grant that's allowed to other private schools. So the vote, it turned out, was not as narrow as Roberts had originally feared. Roberts had feared that it would be 4-4 without Gorsuch. Well, it was a 7-2 decision, overturning the Circuit Court in favor of the school. The breakdown was that it had all of the court's conservatives, so it had Roberts and Kennedy and Alito and Gorsuch and Thomas voting for it, and 2 of the liberals. It had Kagan and Breyer also voting for it. The only dissenters were Sonia Sotomayor and Ruth Bader Ginsburg. But there are important implications of the way this vote broke down. Because, well, in dissent, Sotomayor wrote the dissent signed onto by Ginsburg that no court has ever held that any church has a right to receive money from the government, that the state is compelled to pay money upon application by a church. And so Sonia Sotomayor wrote that this would completely overturn the Establishment Clause and would make church-state separation, turn church-state separation from a constitutional mandate to a constitutional slogan. The Justice Breyer concurred with the decision only. Breyer did not concur with anything that was written in the decision. He disagreed with all of it. He thought that the court took the wrong approach, that it was viewed as a church-state separation case, and Breyer's position was that we don't have to look at church-state separation issues at all. This is just an equal protection case, that the government acted in a discriminatory way by taking something that's supposed to be available to all groups and denying it to this particular group, Trinity Lutheran. The important dissent was from Neil Gorsuch, signed on to in concurrence by Justice Thomas. And it involved just a single footnote. Now, an important issue everyone in the court realized was, what is the scope of this case? What sorts of issues are we dealing with here? And Roberts wrote into his decision a little footnote that said, this case applies to discrimination against religion on the issue of a playground surface only. We are not dealing with issues of subsidizing religion or of discrimination on any other grounds. And Gorsuch and Thomas dissented from that. So they wrote a concurring decision that said that, no, the reasoning in this decision should apply to all cases in which government benefits are denied to a religion. Mm-hmm. Now, it's sort of a nuance as to how this affects the importance of this decision. Certainly, what the religious right wants is to overthrow the Blaine Amendments in every state so that they're no longer a consideration. What Roberts' original footnote intended was not to resolve the question, but to say, this decision doesn't resolve that question. That future courts are going to have to decide, and you don't rely on this decision to decide these other cases. The dissent, the two dissenters from this decision held that, yes, when you're considering future cases, you should be considering the reasoning from this case. So what it meant is that this one footnote does not have the force of the decision. It does not have the consensus of the court, because it was 7-2 before. You had, and you need 5 in order to have the majority in a decision. Breyer did not agree, did not concur with it, because he didn't agree with anything in the decision except the decision itself. And Gorsuch and Thomas did not agree, so that reduces the number of people supporting this point to 4. So when future Blaine Amendment cases are being considered, the trial courts may indeed look to this decision for guidance. So that is the history. Now, the importance of this decision is they want to do away with the Blaine Amendments, and the gold ring at the end of the race would be if they can force states to subsidize sectarian schools. Sectarian schools, even though they're teaching history and mathematics and reading and all of those things, have a religious intent and perform religious indoctrination in the classroom. And so this would put the governments of the states into the position of an alliance, a funding alliance in which they are providing government assistance directly to the cause of religion.
Okay. Neil Gorsuch's confirmation, it was quite contentious. And the Democrats were united in a desire to filibuster that would have required 60 votes to bring his nomination to the floor. But Republicans were able to change the rules to invoke what was later called the so-called nuclear option to confirm him with only a simple majority, and it was 54-45.
Yep.
In that decision, do you think that Gorsuch's legal philosophy on church-state separation was an issue?
Not very much. There were only a couple of days of hearings. The main issues that were brought up were things like a decision that Gorsuch made about a truck driver whose truck broke down in freezing weather, and the truck driver was feeling was extremely cold and was losing feeling in his hands and was miserable, and the dispatch company told him that he had to stay there in his truck and could not leave the trailer with all the goods he was carrying behind. It got to the point where the driver was fearful for his life, and so he unhooked the trailer and drove to get assistance for himself. And he got fired because of it. And so he was questioned, most notably by Senator Al Franken of Minnesota, about the seeming barbarity of this decision, but Gorsuch defended it. Church-state separation is not the top issue for most of the senators, and it was not one they especially got to. Now, there are groups to which I belong, groups that are very influential and important in the atheist community, such as Americans United for Separation of Church and State and Freedom from Religion Foundation, who did take positions. And they looked at Neil Gorsuch's record in questions of church-state separation, but also of issues related to the influence of the church on public policy. Issues such as same-sex marriage, gay rights, reproductive rights, and so on. And all of them opposed Neil Gorsuch. Now, the curious thing is that Gorsuch's amendment was delayed for nearly a year, during which time no consideration was given to the nominee from President Obama, who was, suddenly his name is slipping.
Merrick Garland.
Yeah, Merrick Garland, right. And the thing that was unusual about Merrick Garland is that he had practically no track record at all, no signature on church-state separation issues. He had been involved in, I think, 4 cases that involved freedom of religion, and his decisions in those 4 cases was split. But he was on the Washington, D.C. Circuit Court of Appeals, and they have an unusual docket. Most of the cases that are brought to that court involve government regulation, brought by businesses trying to get relief from onerous government regulations. And so Merrick Garland had a world of record on that, but not in church-state separation issues. So the main thing that the secularist organizations wanted was hearings. And we wanted senators to ask Merrick Garland his opinion on these church-state separation issues. And we never got the hearings. So no one ever took a position on it.
I see. You're familiar with Hobby Lobby stores versus Sebelius, that case?
Yeah. And,
what were the issues in that case?
Okay. Hobby Lobby did not want to comply with one of the mandates of Obamacare, the Affordable Care Act. That being for providing contraception for their employees whom they insure. And the 10th Circuit in the case Hobby Lobby v. Burwell, they took the case, and the court took that position, and Neil Gorsuch concurred in that decision. Now, that decision, essentially the same court went to different jurisdictions, and in different jurisdictions there were conflicting rulings, which is a reason why the Supreme Court took it. And the Supreme Court actually ruled on a different case. The Supreme Court ruled on Zubik v. Burwell. Same issues. And the court concurred with the decision of the 10th Circuit, saying that Hobby Lobby is a closely held corporation, meaning that it's only owned by a family, by a small group of people who are unified in their religious outlook, and so that in this case of a closely held corporation, that they do have religious rights. The corporation does have religious rights. Now, this does not imply that any corporation has religious rights. You know, certainly not corporations that are traded on the New York Stock Exchange, for example, because then the owners are widely held, broadly held. Ownership is widely held.
Mm-hmm. And in that case, I take it that Justice Gorsuch held with the conservatives.
Yes, yes. Gorsuch held that corporations can indeed have religious freedom rights.
You're familiar with the case, the Little Sisters of the
Right.
Poor Home versus H. V. Burwell?
Yeah. This is a case that follows after the Hobby Lobby case. The Little Sisters of the Poor maintained a home for the aged, home for the elderly, and had employees who, according to the Affordable Care Act, needed insurance provided by the Little Sisters of the Poor. So after the Hobby Lobby case, the Obama administration had come up with an accommodation to meet the religious freedom arguments. And they said that if the employer is a religious entity or holds a closely held corporation, holds objections on the basis of religious freedom, that all they have to do is notify the government. And once they notify the government, then the government would tell the insurer that they had to pay for it. Now, that may sound ridiculous at first, but it's not so ridiculous because the insurer benefits from contraceptive coverage because coverage costs go way up for pregnancy and childbirth. So they're really keeping costs down by covering contraception themselves. The Little Sisters of the Poor said, no, we're not going to do that. We're not going to tell the government that we're not going to provide contraceptive coverage because that action violates our religious freedom to something that we object to, which is contraception. That we feel a religious duty to do everything that we can to stop these employees of ours from getting contraception. So we're not going to tell you. And to most people, that sounds like a pretty ridiculous argument, that all you've got to do is say, I'm doing nothing, I'm not providing this, and it's taken care of from there. You don't have to provide it. And Gorsuch, I believe, was in dissent in that case, that he ruled that the Little Sisters of the Poor do have a right not to comply with the Obama administration accommodation.
All right. Since our time is running short, unfortunately, I wonder if you could say your opinion for the free thought community. Is there anything favorable in your opinion about Justice Gorsuch in regards to the free thought community and his influence on the court?
Not much. On church-state separation issues, he's pretty much aligned against us right down the line. But I do think that in one respect at least, he's an improvement over Scalia, who held that position before. And that is an interpretation of the law. That most jurists, considering constitutional issues, look at the law and try to understand what the intent was of the law, what the context was, look at the arguments behind the law, and try to serve the will of the legislature in that way. Like Scalia, Gorsuch is a textualist, meaning he won't look at intent, won't look at the arguments, he only looks at what's written down in the law itself. But in addition, Scalia was an originalist, meaning that in constitutional issues, the only thing we have to concern ourselves about is what the signers of the Constitution had in mind. And so everything that's come up since, like privacy on the internet, for example, the founders had no opinion about that. And so it cannot be a constitutional issue. And at least Gorsuch is not an originalist.
I see. Thank you very much. George, I'm afraid we're going to have to pretty much cut it off there. My guest today has been George Kane, a longtime member of Minnesota Atheists. He writes our monthly news and notes column for the Minnesota Atheist newsletter. And when you contact us, and there are many ways to contact us at minnesotaatheist.org, we will supply you, if you wish, a copy of our newsletter. This is what it looks like. Again, George, thank you very, very much for joining us today.
Thank you, Joseph.
You certainly educated me and hopefully a lot of our viewers. Thank you very much.
Thanks.